Laith Gafour, Principal and Managing Director of Lucentum Sports and Entertainment Law, is with me in studio. Laith, can you explain how this works? Because I think most people hearing this are going to think, well, no one's going to respond if you send something out over the internet. How does this work?
Well, Marcia, first of all, this is a good example where the law is actually catching up to technology. We often hear times where our judicial system doesn't understand what's happening in the real world. So essentially what this means is Mr. Burke's counsel went to the Supreme Court in BC and said there's no other way for us to track down these other 8 individuals. And so they had to show that they made an effort to get in contact with them. And so they showed this by saying that in April, and since then, they've been making efforts to contact administrators, but no one's responded. And so really what this is, they need to show that it's probably or reasonably likely that these folks who are active users on these message boards would get the message that they're being served.
And then what?
And then they have, what they've allowed in terms of the technicality is 5 days after the notice has been sent, that's when the clock starts, and they have 28 days in order to respond to that, just like any other person who's been filed with a notice of claim.
Are there any other legal options available to Mr. Burke and his team to get to these people?
Well, what they've done, and I think this is a great move, in the sense that it allows them to circumvent all the other personal process. And by the way, this is not without precedent. Many Canadian jurisdictions, they all have this substituted service requirement under their rules of civil procedure. It's also quite common in other Commonwealth jurisdictions. There are cases in which Facebook has been used in order for that to be served as notice. The earliest example in Canada comes back in 2009, where service by Twitter was allowed. And so part of this is an example and the courts catching up with individuals who are playing hide and seek. And so I think it's a great example of the law really going lock and step with people who are trying to avoid being serviced. And things you say can come back to haunt you.
Well, what are the legal ramifications here? And you bring up Twitter, and these comments about Mr. Burke were posted on an online chat page, but people get nasty, I get nasty comments on Twitter. So what are the implications here?
Well, I think it's a message. It's a message that the way and the traditional ways in which people are held to standards is starting to change. So we've always had rules about defamation and about slander. But I think, individuals who are high-profile people are realizing, and you've seen in Parliament how bullying happens and cyberbullying happens. And so these are individuals taking things to the next level. And I think it is appropriate that under certain circumstances that individuals have a recourse, because traditionally, early on in the Internet technology phase, people really could hide. And this trolling behavior continues. In terms of the consequence, I think that really these individuals, certainly, publications and these issues going on here are noticed to them, and I certainly think they're going to be tracked down. But going forward is the matter itself. So it hasn't gotten to court yet on its merits, but this is an interesting step, and I think one that our courts are using as a way to, again, track down people who think that they're anonymous online.
Okay, we will be watching. Laith Gafour, great talking to you again. Thank
Always
you so
a pleasure.
much.